Hello, welcome, and thank you for joining us during your lunchtime for this ethnic diversity workshop. We're in the office, but we're COVID secure. I'm wondering if I can give my colleague Liz here a cuddle later on, but who knows. We've got a chat box at the bottom. Put your questions in there, and we've got Jen from marketing in the background. She's going to be looking at those questions and sending the most popular ones through to us at the end. We're going to be about 45 minutes, and then questions will be done by 2. I'm Deborah Scales. I work in the employment team.
And I'm Liz Bradley. I'm an employment solicitor within the same team as Deborah.
So it was Race Relations Act came out in 1976 with the objective of making race discrimination unlawful. That was incorporated into the Equality Act in 2010. But I don't think we've ever had a year like this one, and that's not just because of COVID. The murder of George Floyd last summer galvanised the Black Lives Matter movement all over the world. And here in Britain, it prompted a debate on our history, the state of race relations in this country, and the state of inequalities in this country. We've been, as employment lawyers, had a year of education, as our Employment Law Association have been sending us for 21 days consecutively webinars, podcasts, recordings, poems and written accounts by Black, Asian, ethnic minority academics and writers, historians, which we've been able to read, and so we can educate ourselves. Meanwhile, the business community have been taking notice of agitation from Black Lives Matter in this country. We've had in October 2020, we had the CBI, the Confederation of British Industry, launch its Change the Race Ratio campaign. And the purpose of that is to promote Black and ethnic minority talent into more senior leadership roles. We've also had the Legal & General, which is the UK's biggest fund manager, say that they will not re-elect the chair of the board if by 2022 January it hasn't at least got one Black or Asian or ethnic minority member on its board. So lots of agitation there from the business community. We've also seen big law firms in the city promoting natural hair for its Black women employees. So lots going on, and it may be that with all of the discussion and the debate and the complexities around it, that if perhaps you're maybe a white HR manager or a line manager, it makes the really difficult topic, the challenging topic of discrimination, even more challenging in that there might be a level of anxiety about getting it wrong, saying the wrong thing, using the wrong terminology, and just putting your foot in it. So the purpose of this webinar is to try and help you feel more comfortable talking about the subject and addressing it. And we're going to start with the law and some basic legal definitions, because if you've got a grounding in the law, you're going to be more comfortable. We'll then move beyond the law and we'll look at examining the workplaces, where you start, what to do. And we'll also, if we've got time, I'm sure we will at the end, we're going to look at something that's hardly ever mentioned, and that's positive action. That's allowed under the Equality Act. Positive discrimination is generally unlawful, except in specific cases for disability, but positive action is something that can be used and hardly ever is. So I'll hand you over now to Liz for the first bit of our definition.
Thanks, Deborah. So as Deborah's mentioned, we are looking at the Equality Act 2010. And we're just going to start with thinking about, what is race? What are we talking about in legal terms when we talk about race? So the Equality Act definition goes beyond colour, and it includes nationality and ethnic and national origins as well. So it's just important to be vigilant for the whole range of scenarios that could fall into the category of race discrimination. The APES guidance on race discrimination is a great place to start in terms of just getting to grips with the basics. And one of the examples that they have for nationality-based race discrimination is the example of a French employee working with English colleagues who mimic her accent. They suggestively say la la every time she walks past. They make jokes about wine and cheese lunches, and she finds this all offensive. Talks to a line manager who tells her to just shrug it off. So that is an example of nationality-based race discrimination. We also know from the case law that ethnic origins protects Romani Gypsies and Irish travellers. And in terms of just our current situation, it's worth thinking about COVID. And I know from just LinkedIn, some of you may have seen various messages and posts raising awareness that actually people of Chinese ethnic origin have been experiencing an upsurge in abuse related to the virus. We're in a situation now where the media tends to refer to new variants based on where they were detected first, so the Indian variant, the South African variant. So it's just worth being vigilant for where these sorts of things might crop up in a workplace context or something that could be a basis for abuse. It's also worth pointing out what isn't covered. So regional stereotypes are not covered by race discrimination. So somebody experiencing something along similar lines to the national stereotypes I mentioned in the example of the French employee, but based on regional stereotypes, that's not protected, although obviously you're going to want to be addressing that through your anti-bullying and harassment policies anyway. And I'm sure throughout the course of the webinar, we're probably going to just slip into referring to employees, but it is worth noting that we are talking about protection that extends beyond employee status to workers, to self-employed in their personal capacity, and also to job applicants. So it's really just to make sure we're thinking about the whole ambit of the protections. So that's who. What about what form might this discrimination take? In the Equality Act, we've got 4 types of discrimination: direct discrimination, indirect discrimination, harassment, and victimization. And we're going to walk you through them all with some examples. And I do just want to, at this point, have the little sort of Netflix trigger disclaimer to say that actually, some of the cases that we are talking about, there's some ugly situations, and it isn't nice to constantly kind of be dragging up these experiences and these scenarios, but obviously we do it in the hope that by repeating them, we're going to avoid them in the future. So I'm going to hand back to Deborah to take us through direct discrimination.
Okay, thanks, Liz. So direct discrimination occurs when somebody is treated less favourably because of their race than somebody of a different race would be treated. Whenever you hear the expression less favourably, you know that in legal terms, a comparator is going to be needed. So let me give you an example. A few years ago, a black employee came to me and he said that his boss was a racist, he was being bullied, he was barked orders out all day, and he wasn't paid his overtime. So I asked him who he worked with. He said, I work with Joe, a white guy. How does the racist boss treat Joe? He said, just the same. He barks orders at him, he bullies him, and he doesn't pay him his overtime either. So in that case, there was no legal claim for direct race discrimination because that boss treated the white employee, the comparator, just as badly as the black employee. So there are always going to be bad bosses, and those examples are fairly, well, we hope limited, although they do go on, of course. But in most cases now, most employers are well-meaning, and certainly I know we've got a lot of HR business partners on the webinar, and we know that you do your absolute utmost to ensure that equality and diversity is put into practice in your organisations. But it's a fact that a lot of race discrimination now is so hidden, it's so covert, it's hard to spot and even harder to prove, actually, but it's there. And often race discrimination it comes down to stereotyping. Positive stereotypes are given to the the majority of the white employees, and more negative stereotypes are given to the minority groups. Another word for stereotyping, I suppose, is unconscious bias. Now, that's been in the news all year, and I bet if you're on LinkedIn, you'll see it all over the place. Earlier this year, the chairman of KPMG, you'll remember, he had to resign after he called unconscious bias complete and utter crap. And we also had a government funded report, which we'll talk about later, which said unconscious bias training is a waste of money, don't bother. But unconscious bias isn't a new term that's come out of Black Lives Matter. It's been around for years, and in 1999 it was the House of Lords in the case of Nagaranjan and London Regional Transport who first talked about unconscious or subconscious bias. And I'm just going to read out a quote from the judgment, and this is what the House of Lords said. All human beings have preconceptions, beliefs, attitudes and prejudices on many subjects. It is part of our makeup. Many people are unwilling and unable to admit to themselves that their actions may be racially motivated. And so that case established the reason why test. And it's still good law today, and it's been reaffirmed in other cases. If a case was taken to a tribunal, or if you're looking at grievances or disciplinaries or any sort of treatment in the workplace, what you need to look at is the reason why somebody has been treated in the way that they have. And if the reason why is connected with race, then there is unlawful race discrimination going on. Now, one area where stereotyping, or unconscious bias if you like, is applied in the workplace is during grievances and disciplinaries. So I'm going to take you through two cases. The first one is Mr. Morris, who brought a claim for direct race discrimination against the Royal Bank of Scotland. And Mr. Morris was a black employee, and he brought a complaint against his manager, who was white. The complaint had nothing to do with race discrimination. Mr. Morris didn't raise it. He wasn't saying his white manager had acted in a racially motivated way towards him. They just hadn't been getting on, and Mr. Morris had complaints about his manager's, the way the manager treated him. But the senior manager who got involved assumed it must be a race discrimination complaint and treated it as such. And Mr. Morris found this very demeaning, that he was accused of playing the race card. And the tribunal agreed with Mr. Morris. They said that Mr. Morris's complaint should have been treated like any other complaint on its merits. It shouldn't have been treated as a complaint by a black employee against a white colleague, because if a white colleague had complained about a black employee, they wouldn't have assumed the white person was bringing a race complaint. And that's where the stereotyping came in. The next case is on a disciplinary, and Mr. Hastings was employed by the King's College Hospital Trust as an IT manager. And he had an altercation in the car park, in the works car park, with a member of the public who racially abused him and assaulted him. And it was caught on CCTV, the incident. But Mr. Morris was treated as the aggressor. And this is where the stereotype of the black man as the aggressor came into play, even though at the hospital they'd got, a large HR department and they had people going through the disciplinary procedure. And what the tribunal identified in its judgment were these particular failings. One, Mr. Hastings as the black man was treated as the aggressor. The white witnesses in the case were treated as the victims. Mr. Hastings' evidence was prefaced with, according to AH, as though it wasn't reliable. the white witnesses' evidence wasn't scrutinised, even though there were inconsistencies in it, and Mr. Hastings' own race discrimination grievance was overlooked. Mr. Hastings won his claims, and in fact he became so ill as a result of the treatment that he was then unable to work for some time. He got his loss of earnings compensation, which was uncapped as it is in discrimination cases, and his award came to nearly, or just about, £1 million. Now, I'm not highlighting that case because it was a big payout. I'm highlighting it because of all the stereotypes that were applied and how the trust got it so wrong. I'm going to pass you to Liz now for indirect discrimination.
So indirect discrimination, obviously what Deborah's been talking about is very targeted to particular individuals. Indirect discrimination, we're moving into a slightly different area where really at the heart of the definition is a PCP, provision, criterion or practice. So what is that? How do you identify that? It's really anything that you could sort of characterize as the way we do things around here. So it might be in a policy, it might not be, but it's something that applies to everyone, and it's part of the processes of the way the workplace works. They become problematic if that PCP puts an individual at a particular disadvantage because of their race, because they belong to a particular racial group, all the different definitions that we talked about. So what might that look like? The Equality and Human Rights Commission Code of Practice is a great place to look for examples and for guidance. It's a statutory code, which means that the tribunals take it into account when they're trying to understand how to apply the Equality Act. So it's a really good authority. One of the examples that they give of indirect race discrimination, or where it might occur, is in relation to eligibility to work in the UK. So obviously an important question, needs asking. But where do you put that? Where do you ask that question within your recruitment process? So the code suggests that if you're using that question as a gateway question, if it's one of the first questions that you have in your application process and people can't progress if they say they're not eligible to work in the UK, that could lead to indirect race discrimination, because you're essentially preventing yourself from exploring the possibility of whether you could help a suitable candidate who's got great skills, a lot to offer your organisation, become eligible to work in the UK through various visa channels. So because you're not giving that candidate, that potential candidate, enough space and time to prove themselves before asking the eligibility question, you're potentially, excluding people who, on the basis of their nationality, can't show you what they could offer. So that's something to think about. Another example from the case law, that we don't have loads of examples in the case law, to be honest. Other forms tend to be pleaded more often. But in this case, Ministry of Defence against Dabiq, and the claimant was a mother. She was a citizen of St Vincent and the Grenadines, and she was in the British Army serving as a foreign and Commonwealth soldier. As part of her role, she was expected to be available 24/7 for duty, and she was disciplined when she wasn't able to meet that requirement. Now, the reason she couldn't be available 24/7 was because she had a child to take care of. And the Army had a childcare policy whereby a relative could come and support soldiers with their childcare needs, but that relative could not come from abroad. So they had to be UK based already, and they said that was because of immigration complications. Obviously, that's going to put people at a disadvantage whose relatives are not living in the UK. So this is where the indirect race discrimination came into play. And the tribunal held that it wasn't justified because the Ministry of Defence hadn't given any thought to how that policy would impact differently on the foreign and Commonwealth soldiers. And we hadn't thought about how to mitigate it. The tribunal pointed out the Army could have stepped up and helped with childcare. Or they could have had a chat with their friends at the UK Border Agency, like they've done in the past, and worked out the immigration issues. They basically just hadn't thought about it. They hadn't considered how the policy would affect people from different backgrounds. So it's really just awareness, thinking through the implications and the impacts of a general policy, because it might not be evenly felt by all. But it can be justified, indirect discrimination can be justified in contrast to direct discrimination in other forms. The justification is proportionate means of achieving a legitimate aim. And the really important word is proportionate. So again, looking for examples of where we might see this justified or not. Language requirements is something that the Code of Practice points out could be justified, but in certain contexts. So you need to think about what is absolutely necessary and not going beyond that. So the Code talks about customer services role, employees who are the public face of the organisation having a particular standard of language requirement for those roles would be proportionate. But if you're applying that same role, that same standard to roles that aren't public facing, then it's likely to be disproportionate. So it's thinking things through, how far do we need to go and not going beyond that. A case where, again, sort of people went beyond what was necessary was Rogers against the London Borough of Barking and Dagenham. And in that case, we had a redundancy scenario. People were being asked to apply for new jobs. Obviously a smaller pool, so very competitive. And as part of that process, they had to undertake written exercises. They weren't allowed to access online dictionaries, no Google Translate, no support whatsoever. And that was disproportionate because it was completely unnecessary for the requirements of the role. It was more stringent, and it put people whose first language is not English at a disadvantage. So that's indirect discrimination. I'm going to move on to harassment. That's something we do see included and kind of comes up just much more often in the context of race discrimination. So what is harassment? It's unwanted conduct connected to race, which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. So a few things to pick out from that definition: purpose or effect. That's really important. It means that unintentional harassment is caught by this definition. But sensitivity is also considered, and there's a case that helps us to kind of think through that I've put up on the slide. It's Richmond Pharmacology against Gallagher. And here, the claimant was of Indian ethnic origin. She'd referred to the possibility of getting married and giving up work. She said her parents wanted her to get married, and she was also due to visit India shortly. And in that context, somebody in the workplace made a comment about her being married off in India. Now, is that harassment? Is that race discrimination? The tribunal, I'm not going to read out the quote because it's massive, but you can do it yourselves. But the tribunal basically engaged in a bit of a weighing exercise to kind of consider the sensitivity of the claimant, but also considering the impact of kind of creating a hypersensitive culture in the workplace. And they did come down in this case and say, because of the stereotype of forced marriage and the context, this was harassment. But really, you just don't want to be in a situation where you're splitting hairs and seeing what you can get away with. And what you want to also take away from this case is it was a one-off incident. So harassment in the Equality Act doesn't require a course of conduct. It doesn't have to be going on for a long time. Often, unfortunately, these situations are going on for a while, but that is not a requirement for somebody to have a valid harassment claim. It can be a one-off incident. And also something that doesn't often, it can kind of go under the radar, is that harassment claims can be brought by people in the environment. So it doesn't have to be brought by the person who the comment was directed at, or a person who shares the same racial identity. So, for example, if somebody said something derogatory about me because I am Black, and they said it and I wasn't there, I didn't hear, but Deborah heard, and it made Deborah feel like, where I'm working, this is a hostile, offensive environment, that's a harassment claim right there. So it's really important to understand that we're talking with harassment claims about the overall workplace culture. So as an employer, when can you ever put your hands up and say, like, we tried, we really tried, but this is just a rogue individual, it's a one-off, we shouldn't be liable here. The Equality Act does have a reasonable steps defence, which is basically along those lines, saying we took all reasonable steps to prevent that unlawful conduct, but it's not easy to use. We've seen a recent case Ali UK Limited against Elon, where a harassment claim, the claimant of Indian origin was experiencing comments like about his brown skin, going to work in a corner shop, all sorts of horrible things along those lines. And the employer said, we did equality and diversity training 2 years ago, so, not our problem. This, we tried. And the tribunal did not have time for that. They said the training was stale and ineffective for several reasons. One, it didn't stop the perpetrator from making racist comments, but also it didn't equip the other people in the environment to respond appropriately either. The colleague and manager who overheard the comments did nothing. The second manager who overheard the comments actually engaged with the claimant and said, you should report this to HR, but didn't go on and report it to HR himself. So if you're doing equality and diversity training and it's actually not addressing issues in your workplace, that's a really big red flag to say that you need to step up your training, you need to do it more often, but also you need to think about making it more applicable to the scenarios that you're seeing. But what if, things go right in the sense that people do report behavior that is inappropriate, but they face a backlash? That brings us on to victimization, which Deborah's going to cover for us.
Okay. So just another point on that Gellan case actually is that what the UT said was that the manager who'd overheard it should have reported it. So sometimes we hear from HR who say, well, we can't deal with this incident if you're not going to bring a formal grievance, and people don't always want to do that. If you know something's going on as a line manager or HR, you need to be investigating it even if a formal grievance hasn't been submitted. So when a formal grievance or discrimination complaint is submitted, or somebody supports somebody who's making the complaint or makes the complaint on behalf of somebody else or brings a claim, those are all called protected acts. And if somebody is treated badly because they've done a protected act, that is unlawful victimization. Victimization has this legal definition in the Equality Act, and it's not simply the everyday English language that applies here. It's a specific thing. Now, in this case, Mrs. Panahani Jand against the Berks Health NHS Trust. This is one of my absolutely favourite cases. I really love it. It's so encouraging. It's a fantastic case. It's just at the Employment Tribunal level. It came out a few months ago, February. And because it's at the Employment Tribunal, it means it's not binding on other cases. But what we're really hoping is that the judgment in this case is really going to encourage people to stand up against racism at work. And when we were talking earlier on about the Black Lives Matter movement, it's about not just not being racist anymore, but actually being anti-racist and calling out racism when you see it. And that's exactly what the claimant in this case did. She was a paediatric nurse at the hospital, and she noticed that the workload and the staff room was divided on racial lines. There were the so-called white Essex girls, and then there were the black and the Asian nurses and staff. And she noticed that the black staff were given the hard and more difficult, more dirty jobs, and that two black nurses particularly were being bullied. So she decided to raise this with management and bring complaints on behalf of those two black nurses who were bullied. And she persisted in this, and HR's, well, we'll look after it, leave it with us. But she was determined to keep fighting it. She thought it might be brushed under the carpet, and eventually she was disciplined herself. They stopped giving her any more bank shifts because she was like on a 0-hours contract, so they didn't have to. So that's an act of victimisation. And she was treated with aggression, bullied in the car park, and so on when she bumped into a manager. And the judgment of this, I'm just going to, we'll just read it out because it's just so great. It said, and this is what the tribunal said, race discrimination can only be identified and resolved if working people blow the whistle. The claimant was not raising these concerns in her own private interest. She thought race discrimination was wrong and the hospital had a public equality duty. She was trying to be a good citizen. Fantastic. Next slide. So we've got all of these reports going back from 2016. We've got this new report that came out a little while ago, which was commissioned by the government, the Commission on Race and Ethnic Disparities. That drew a bit of controversy in the papers. It said there was no institutional racism in Britain. It also criticised the use of the term BAME. Lots of people don't like the term BAME, understandably. It's a huge kind of cover-all for lots and lots of different people, nationalities, different religions. And it also, this report also said that unconscious bias training was ineffective, and the government should stop funding it in the civil service and so on. But some of the things that this report did recommend was in line with the rest of the business community and in line with what the CBI are recommending, which is ways to alleviate people underrepresented in management positions up through the ranks, to give them more training. And one of the recommendations in the report was for targeting apprenticeship schemes at underrepresented groups. Encouraging more entrepreneur apprenticeships from the underrepresented minority groups. So this leads to the question, with all these new calls from businesses and the new Let's Be Anti-Racist, what can we do? And is there going to be a backlash from white people, possibly, who say that they are now the ones being unlawfully discriminated against, receiving the less favourable treatment? Well, positive discrimination is unlawful in this country, aside from some exceptions for disability. But there is something called positive action under the Equality Act. And in my 15 years of working in discrimination law, I haven't had any cases on this, because it's quite a tricky thing to apply. Well, you'll see why in a minute when I explain the case. But it might be something that's worth exploring now. So first of all, Section 58 is the general positive action rule, and the purpose of this positive action is to redress the balance where one group in society are underrepresented. So some examples from the EHRC that could amount to lawful positive action: prayer rooms to encourage more Muslim employees to your workplace, or English language classes for employees whose English is a second language. And the recommendations made in that report I just referred to, which was to offer more apprenticeships and entrepreneur kind of classes, and that would be an example of positive action. Section 59 is used in recruitment and promotion, and this is generally meant to be used in a tie-break situation because it's for circumstances when you have equally qualified candidates. Now, let me give you an example. It's a fact that in this particular workplace, black managers are underrepresented compared with the local population and the local workforce and the number of employees at that business. Therefore, if two candidates presented themselves, one black and one white, and they were equally qualified, the business could lawfully choose the black candidate over the white in order to redress the balance and deliver more black managers to the business. One of the cases on this a little while ago was brought by a straight white male against the Cheshire Police. He was applying for a position to be a probationary police constable, and the positions went to members of the ethnic minority communities, to women and to gay people, because they wanted to get, the police force wanted to get more of those people into the force because those groups were underrepresented. It just so happened that Mr. Furlong was actually better qualified than all of the other candidates, and so he won his claim for direct race discrimination as a straight white male. So what you need to do when you're using if you want to use this positive action, and I should have said there's no legal obligation on business to use it at all, is you need to start with the data. So to justify it, you want to have some idea of where you're underrepresented, and then a strategy for what you want to do, for the number of managers that you need to bring up to the ranks to address that imbalance and that inequality. And here's a quote from Baroness McGregor from one of the reports from 2016. No employer can honestly say they're improving the ethnic diversity of their workforce unless they know what their starting point and they monitor that over time. So I'm now handing you back to Liz for a section on data.
Stay with me. Don't let my word make you log off. Data, let's think about it in two ways. So we will get on to statistics, but actually a really important part of data is narrative data, such surveys, understanding people's views and perspectives through how they describe the workplace, how they describe their experience of it. And that's something that the CIPD Race Inclusion Report, another report from this year, has particularly picked up on, and just talking about trying to understand people's perspectives on whether the conversation is important, what obstacles there might be to having that conversation. And that's a really interesting survey, just in terms of the answers that were given and ideas for a starting point maybe for your own survey. If you are thinking about canvassing views on ethnic diversity, two things to think about is the who and the how of that conversation. So it's understandable that organisations might want to give particular space to people who may have a lived experience of these issues, but it's important to make sure and to stress that racial inclusion and diversity is everybody's responsibility. So not just seeking the views of ethnic minorities, but also thinking about how the conversation is relevant to everybody in terms of their work as well as their experience as an employee. So thinking about roles, thinking about are you a line manager, are you a mentor? Could you be a mentor? Are you, working in HR? Trying to make sure the conversation is as collective as possible. And it's also just worth being sensitive to the fact that people will have different emotions and different levels of willingness to engage in the conversation to begin with. So for some people, they might be really, really, ecstatic that finally somebody is raising the issue. But for other people, it might be quite othering, and maybe they don't want to have to kind of explain all of their experiences to everybody. It might be quite traumatic. So how you have the conversation is also important to think about so that you can help people to engage in a way that feels appropriate and comfortable for them. So could you have a range of options? Could you have an anonymous online survey right through to, at the other end of the scale, roundtable or reverse mentoring where you've got one-to-one conversations. So just making sure that if you're going to start a conversation, you think about offering it in ways that are varied so that people can engage in a way that works for them. And an important part of that conversation will probably be language. This is something that the CIPD survey picked up on. They asked people, how do you think, or how would you like to be referred to? I can't remember the exact wording of the survey, but it's in the report. And one of the things that they found in their research was a preference for, a slight preference for ancestral preference. So for me, that would be Caribbean or Afro-Caribbean as opposed to Black. But it also didn't follow from their survey results that people thought other terms were inappropriate. So I do refer to myself as Black. There's a great book by David Olusoga, Black and British. It's a term that I use and that people do use, but other ethnicities might not be so comfortable with colour labels. So if you don't know, ask, and if you don't ask, you won't know. So it's a conversation to be had. Moving on to the other aspect, which is more statistical, we're kind of looking at whether or not you want to go down the route of ethnicity pay gap reporting, looking at an understanding of what your diversity is within your organisation. We don't know where we're going to get to with mandatory ethnicity pay gap reporting, but already various organisations have started to report annually. If you want to go down that route, it's worth thinking about a few things, both in terms of information gathering and then moving on to reporting. So information gathering, the kind of research and people kind of talking about how their experiences have worked, case studies tend to show that where you're only asking at the start of the employment journey when you're onboarding your new recruits, you don't actually get a very high disclosure rate at that point. The more successful organisations in terms of high disclosure rates ask often. And there might be, a whole range of reasons why people don't disclose at the outset, and obviously it's always voluntary. But once somebody's settled into the organisation, once they're comfortable with their colleagues, they kind of understand the workplace culture, they might feel more comfortable disclosing, so it's worth asking often. But I think the more important point is covering why you're asking, what you're going to do with this information and what you're not going to do with this information, so that trust is built up around that exercise. And then if you do want to move into reporting, we tend to see that actually reports have mirrored gender pay gap reporting, so kind of binary, BAME, non-BAME, but as Deborah's already mentioned, that's a very kind of broad and masking term. So it is worth thinking about how can we make that more useful. If you are thinking, like Deborah said, about recruitment, maybe you want to map onto census data so you can actually compare the data on your geographical area to the data within your organisation. It's just thinking about what is going to make it useful for you. We're at a point where there's no mandatory rules, it is flexible, make it useful, make it practical. So Deborah's going to take us through some more practical considerations too.
Okay, so strategy, and you need to work out what your objectives are and try and measure them over time. But communication is a really important thing, and I referred earlier on to the businesses that have put in the black squares on their websites. If that is just paying lip service, if there's no black managers, no progression for black or ethnic minority people, it's just pointless. It's going to backfire. And so what you really need is absolute commitment from the top. And so your communication, not like the KPMG manager who say stupid gaps like unconscious bias is crap, but you need some communication there that can be open and trusting. And I put a reference there, say my name, say my name. I'm told it's Destiny's Child, not Beyonce, as I earlier got wrong. But lots of us voluntarily choose to shorten our name. I'm Debbie in my social life outside work. But a lot of people from ethnic minorities who have names that are initially unfamiliar to the white British population will shorten it in order to make life easier for us. Now, years ago, I worked with a British Indian lawyer whose surname was Patel. That was really easy. We could say it, we could spell it. But his first name was difficult to pronounce and difficult to spell. One day he came into work and it was years ago, he'd been watching Barack Obama doing some electioneering to get into the White House. And Barack Obama had said, I used to call myself Barry, no more, I'm Barack. And my colleague came in and he said, from now on, you can call me by my proper name. I know it's hard for my clients. Our clients are mainly, white English people, but that's what I'm going to do. And we all supported him in that. I struggled to spell it and struggled to pronounce it, but I just tried. And if you're in that situation, if you are a manager with a name that you would really like to use, or anybody you'd like to use, just help people pronounce it, let them know that's what you want. And support that as much as you can, because that makes people feel like they're fitting in. They don't have to fit in with the dominant culture. And talking of dominant culture, we've got Boris Johnson talking about going to the pub every 5 minutes. If you've got people, employees, for religious reasons, say Muslim people or whatever, or anybody who doesn't want to go to the pub, if all your social life and the networking and getting to know colleagues is down the pub, now that they're open again, you're going to be excluding, people, which is just not a positive thing to do at all. And not only are you excluding people from certain religious or ethnic backgrounds, you're excluding possibly people with childcare, people who can't afford to go to the pub, and people who are just shy. So watch out and probably have some alternatives to that. And other measures include mentoring and reverse mentoring, and that's when you would have, I would say to Liz, I did this a little while ago, this webinar. I said, Liz, what terms shall I use? Ask people, get people to help and talk, sponsorship and support. We've talked about those things. And that's part of the CBI program as well. So behind the scenes now, Jen is putting together the questions, and she's firing some over to us, which we're going to pick up on our phone. But I'm just going to pass you over for a final word from Liz before we take questions.
So we just wanted to offer a space and a little pause, which might feel uncomfortable, but we're going to do it anyway, because I think if you're serious about starting conversations about race, you've got to learn to sort of push through the discomfort a little bit. And what we wanted to do is just give some silence for reflection, because I think one of the difficulties with race discrimination, obviously we've had legislation with us from the 1976. It's not a new topic in that sense, but it's often a very reactive topic. But really, proactive action is much more beneficial, strategic action. But it's hard to do that. It's hard to fit that in when you're firefighting in your job and there's all the daily demands. So actually taking time, having space for a proactive mindset. What is the next step? This webinar, it's so glad that you've joined us. But it's a step. What's the next step? What have you learned? What have you heard? And what might the next step look like for you?
Okay, so we've got some questions in, and one has come in. I'll grab this first one, Liz. Said when I was talking about that Nagaranja case where about unconscious bias, I read from the quote, and it said all of us have preconceptions. It's part of our makeup. So if we've all got them, what can we do about them if it's part of our makeup? Well, the simple answer is that the more people mix at work with different people of different backgrounds, the more natural it becomes, and the more negative stereotypes will fall away. It's as simple as that. So the more that the underrepresented members of our society become a full part of our society, become part of management, become in positions with us, that's how you're going to get over the stereotypes that are part of our makeup. Liz, go on.
So this question comes up quite a lot actually. It's on ethnicity pay gap reporting, and it's about consent. Do we need employee consent to publish ethnicity pay gap reports? The short answer is no. By the time you're dealing with that data in that form, it should be anonymized. Once you've got anonymous data, you're not within UK GDPR anymore. Anonymous data is not personal data, but there are a few caveats to that. So obviously beforehand, before you get to that point, you're dealing with very sensitive data, special category data. Generally, we don't like to rely on consent in an employee context where we can help it, because consent needs to be freely given, and the balance of power between employers and employees is not, you can hardly ever say that it's freely given. special category data, you're talking about explicit consent, which is even higher. Consent can be withdrawn, so generally just we want to stay away from that. The lawful basis, you'd be looking at legitimate interest or public interest, and in terms of special category data, substantial public interest would be the justification you'd rely on, and that would be for equality of opportunity and equality of treatment. But one thing to note also, with your thinking about sort of data protection, if you're reporting in pay quartiles or job categories and you've got so few ethnic minorities in a particular pay quartile, basically everybody knows who you're talking about or could figure out who you're talking about, you're losing the protection of anonymity. So you really need to think about how you present your data so that it stays anonymous. And if you can't, maybe you need to wait until you can before you start publishing.
Okay, and mine is from Leonard, who's a HR manager with a courier company. He said his workforce are mainly men in their late 50s and 60s, a fairly traditional workforce. He's had somebody refer to one of the customers as somebody of colour. He's confused over whether that's an offensive term or not. He's read there was a report some of you may have seen in People Management a few weeks ago on a case where the tribunal in that case said that the man who'd used the term coloured to refer to other people, he hadn't committed any unlawful harassment because he'd genuinely thought that the term was a polite one and he hadn't meant any offence. And Leonard said, you've confused me because in your presentation earlier on, you said the purpose or effect. It doesn't matter if you don't intend any offence, it's still the effect. Yes, but remember, Leonard, what we had there was that second test on hypersensitivity. So the person who said they were offended by that, would it have been reasonable? But you're right, I know that terminology is really difficult at the moment, especially in America. I'm a person of colour is used a great deal. It's come back into vogue, just as gay people will now use queer. They've taken back the term, and these terms, definitions, it's not just on race definition, on race discrimination either. It crops up all over the place. In disability as well, we had a controversy that Cheshire Homes, Leonard Cheshire Homes were in trouble because they wanted to stop using the word blind. And people on Radio 4 the other day, showing my age, said, well, we want to be called blind because that's what we are. It describes what we are. So terminology is difficult, and we go back to that strategy, that last page where open dialogue, talking in a trusting way. What would you like me to call you? Or do you have to label anybody at all anyway? Learn their name, say their name, and there we are. You should be fine. Thank you for joining us. We know it is a difficult topic. We'll be doing another one of these, and not necessarily us, it might be us, but we'll be doing another one of these lunchtime sessions. That'll be on disability discrimination, another tricky topic. Please join us. You've got our details there on the screen. Message us, talk to us. We'd love to get to know you. We're here to help. And thank you very much, and enjoy your afternoon. Thank you.